my name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction software and research company. And SunRay secures over $9 billion annually in lien and bond claim rights for thousands of subcontractors and suppliers throughout the USA. And today we have another fabulous webinar on the lien law just changed. Are you ready? Without further ado, I would like to introduce Alex Barthet, board certified in construction law by the Florida Bar. He has been repeatedly selected by his peers for inclusion in the best lawyers in America and Florida super lawyers within the specialty of construction law. So, Alex, please begin.
Thanks, Ariella. Everybody, my name's Alex Barthet. As Ariella said, I am a board certified construction lawyer here in Florida. And it's not very often that the lien law changes, but when it does, typically those changes are significant. So today we're going to talk about some of the most significant changes that happen to the lien law so that you are ready when those changes take effect. So specifically, today we're going to talk about how residential building permits can be closed with some recent changes in the law. The legislature also upped the criminal penalties for contractors with respect to residential deposits on construction projects. And then the big one by far is how to make a claim against a payment bond, the new form and the new process, which is important whether or not you make claims. If you make claims on payment bonds, you want to know, and if people make claims on your bonds, you want to know because they may do it incorrectly. We'll talk about the penalties associated with an improper bond claim, and then you'll see a little bit about SunRay's online system and how it's updated for all of these new changes in the law. And finally, if you have any questions, you can submit them through the GoToWebinar chat box on your screen. All I ask is that you make sure that you don't include any names of companies or people in your question, and we will answer all the questions at the end, but you can ask them as we present. So let's get started. So the first change is with respect to closing residential building permits. Under the statute, when a property owner is trying to close a permit that may have been left open, the owner can hire the existing contractor, the contractor that originally pulled the permit, or they could hire a different contractor. The most important change in the law is now that if they hire a new contractor, which may be you, you are, under the statute, not liable for any defects in the work performed by the original contractor. The problem was that new contractors were hesitant to do work under an old permit because they thought that they would be potentially liable for things that they didn't do. The statute was revised to make it very clear that that is not the case. You only are responsible for the work you do, not responsible for the work that was done by somebody else. So let's talk about criminal penalties for residential deposits on construction. So this change in the law happened on July 1st, so just a little bit ago. And it was amended to make it easier for homeowners to press criminal charges against contractors with respect to the deposits. So let's talk about when it applies. So when a consumer for residential construction makes a payment in excess of 10% of the contract price, you as the contractor have to apply for a permit within 30 days, and you need to begin work 90 days after that permit is issued. Now, if you don't, the homeowner can make a written demand. And this is really what kicks off the process. So once that written demand is made by the owner to the contractor has to do one of three things: apply for the permit, start the work, or refund the payment. Now, if you receive money in excess of the value of the work you perform, this is beyond just the 10% deposit. So let's say you've got a contract for $100,000, they've paid you $60,000, but there's only $30,000 of work in place. If, so in that example, the one I just gave, you have now been paid for more than the work that's in place. If you fail or refuse to perform any work within any 90-day period, or any period that's mutually agreed upon in the contract, if you receive a similar notice, you could be found guilty of either a felony or a misdemeanor, depending on how much in excess you've received. So, absent just cause, or if the contractor doesn't properly terminate the contract, then the owner can make a written demand that you perform the work or that you return the money. A big change in the statute was that now, once that notice is given, if you do not properly respond, the court can actually just assume that you didn't have just cause for complying after receiving that 30-day notice. So as you understand, in most instances, you're presumed innocent unless proven guilty. This is an example that upon receipt of that notice, you are, to a great degree, assumed guilty unless you prove yourself innocent. It's a big reversal in the law with respect to these issues. Now, anything over $1,000 is a felony, which, as you can imagine, as a licensed contractor, you'll now have to report all of this to the board, and it becomes a stain on your license, and you may lose your license. One of the big defenses that existed before was that a contractor could argue that there was no intent to defraud. The problem now is that if more than 30 days pass after you receive the notice, it is going to be presumed that you had the intent to defraud the homeowner. So there's no defense that the contractor intended to return the money. Oops, it was a mistake. I meant to return the money. So what's absolutely critical, as if you've noticed in what I wrote, if you have a contract that spells out the payment schedule and the timeline for work and you follow that schedule, then you're okay, even if the schedule exceeds the time limits in the statute. Additionally, if you have a problem with an owner, you may want to terminate the contract per the terms of your contract before the owner could make a claim against you, because once the contract is terminated, then it becomes a civil issue. It's much less likely to be a criminal issue. So let's get on to the payment bond claim process and the new form. So effective on October 1st, just a few weeks away, the notice of non-payment must be served on the contractor and the surety. And unlike the prior form, which was a lot like a letter, it just said, this is who I am, this is how much money I'm owed, you put it in the mail via certified mail, sign it, and you're good to go. This new form must be made under oath, means you have to swear to it and have it notarized. And it must include, as of the date of the notice, the following pieces of information. And I will show you the form in a minute. You need to describe the nature of the labor or services performed or to be performed, the materials furnished or to be furnished, the amount paid on the account to date, and the amount owed, and if you know, the amount to become due. Let's talk about that last item so you understand how it works. If I have a $100,000 contract and I haven't been paid and I need to make a claim on the contractor's payment bond, if I've been paid 60 and I'm owed 20, so I would say the amount paid on the account is 60, the amount owed is the 20. If known, the amount to become due, in my example, would be 20, right? I had a $100,000 contract. At the point in time when I submit the notice, that would be the math. Now, if you are a material supplier and you just supply materials as they are requested, then the amount to become due would be zero, right? Because until you get the next order, you don't know that you have an obligation to ship anything else. So you also need to include in this form the amount of retainage that you may be owed at the time. Now, always remember, the law hasn't changed in this regard. The failure to serve, the failure of a lienor to receive retainage sums not in excess of 10% of the value of the labor, services, or materials is not considered non-payment, requiring the service of a notice. So let me explain what that means. If you are owed, let's say, 10% retainage, and that's all you're owed, the time period to serve your notice doesn't even start to run. So if you've been paid down and it's 5% retainage is all you're left to be paid, you don't technically need to serve that notice of non-payment, which, as you know, is 90 days from your last work on the job. Now, if you're owed 10% retainage and $1 of contract work, now you need to serve the notice for the full amount. So keep that in mind with respect to timing. There is no harm in serving a notice of non-payment, even if all you're owed is retainage. So if you have any doubt, always serve the notice. And here is the form that now exists in the statute. So it's titled Notice of Non-Payment. It's addressed to the contractor and the surety. You'll list both of their addresses. And it has the blanks for all of those sections that I indicated. Now I'm going to see if this works here. We will send out to everybody the handout. Now, if you have the form, you should be able to see the handout called Notice of Non-Payment Form. You should be able to download that. If you can't, just send an email to us and I'll send you, you'll have our email address at the end of this presentation, and we will give you this form in Word format so that you can use it. But we'll also talk about why you may just want to have a service like SunRay take care of it for you. So let's walk through the rest of this form. You need to describe the materials and labor that you've provided, the amount that's unpaid, and the amount of unpaid retainage. You list the amount that you've been paid to date, and then you have to swear under oath that all of this information is true as of the time of the notice. So let's talk about some of the penalties and why this statute changed. To give you a little bit of history, the primary drivers for the change in this statute was the contractor lobby and the surety lobby. They have been pushing hard because they wanted to force subcontractors and suppliers to provide more information when a claim is submitted. The old form, as I said, was a letter, was not notarized, and it just listed how much you were owed. It provided no other information. So what are the penalties now if for an improper bond claim? As you may know, if you record a lien and that lien is found to be fraudulent, there are penalties. There was no fraudulent bond claim. So now, because the document is notarized, if you submit a notice of non-payment that's determined to be fraudulent, you will lose all your rights under the payment bond. It is a complete defense for the contractor and the surety to not pay you and to defend against your notice if it is determined that the claim is fraudulent. So what is a fraudulent notice? It is if the claimant willfully exaggerates the amount due, willfully includes amounts in the claim for work not performed or materials not furnished, or they prepared the notice with willful and gross negligence, which resulted in willful exaggeration. So let me give you an example of a situation in which this could be problematic. Let's say you are a material supplier, or I should say a rental company, and let's say you rent shoring and forming equipment, and when it comes back, you haven't been paid all your money, and you realize that of the $50,000 you're owed, $5,000 is for lost or damaged material. That $5,000 is not lienable, and it's also not a proper claim for against the bond. So if you include in your notice of non-payment against the payment bond surety that claim for the $5,000 of lost or damaged materials, it could be determined by a court that the inclusion of those amounts now makes the entire claim, the entire notice, unenforceable and fraudulent. So you need to be extra careful, just like you are with your liens, to make sure that the math is correct and that you're only making claims for what is truly claimable. That being said, a minor mistake or a good faith dispute as to the amount is not considered fraudulent. What they've done in the statute is they've copied much of the fraudulent lien statute language in cases over to the bond claim. So now the issues that you deal with on a fraudulent lien are the same ones that you deal with on a bond claim. So just like if there's a good faith mistake, the negligent inclusion or omission of any information in the notice that has not prejudiced the contractor or the surety does not defeat an otherwise valid payment bond claim. Now, it's just extra important to make sure that you verify the information you're providing, because you don't want to have this fight if you can avoid it. So if you can make sure that your information is tight, you will minimize the fight associated with whether or not your notice is a fraudulent notice. Now, notices that do not contain the required information or are not notarized or do not track the statutory form are likely to be ineffective. So this is for those contractors or even subcontractors that may get claims against their bond. So as of October 1st, 2019, just a few weeks from now, the form that needs to be submitted to make a claim on a payment bond is the one I showed you. If it's not that form and it's the old form, and the claimant doesn't correct that mistake, the penalty is not necessarily that the claim is fraudulent, it's just that they haven't complied with the law, and much more likely than not, that claim is going to be invalid. So what would I suggest for contractors or sureties that get improper claims? I would suggest that you don't do anything. And when the time period runs for them to submit a proper notice form and they don't, then you can push back and say, well, we don't have to pay because you didn't use the statutory form and provide the information that's required by the law. The last significant change is that bonds issued on or after October 1st, for those bonds, contractors are now entitled to recover their attorney's fees under the insurance statute when they get a judgment against a surety for failing to make a payment under a payment and performance bond. So what does that mean? The old statute was a one-way fee provision statute, meaning if I'm a subcontractor, I make a claim against a surety, and let's say I don't win. So I may not recover the money. I've spent legal fees, so I'll have to pay those, but I don't have to pay the other side's legal fees for beating me. Because, as I said, the old statute was a one-way fee statute, meaning if the insurance company wins, they get nothing, but if they lost, they would have to pay you your fees. This now reverses it, makes it reciprocal. So if I am a subcontractor and I make a claim against the contractor's payment bond and I win, I recover my fees. But if I lose, I now am subject to having to pay the contractor his legal fees or her legal fees for defending against a payment bond claim that I lost and they won. So keep that in mind. It ups the risk profile in making claims and litigating claims against payment bond contractors and sureties. So with that, as I mentioned, the SunRay system takes care of a lot of this for you. So Ariella, why don't you tell everybody about that? Is Ariella there?
Ariella is here. The first, thank you very much, and absolutely, Alex. First and foremost, the new statutory form will be in the SunRay application. So with the SunRay customers that are already familiar with our system, you do not need to worry. That will already be implemented with all of the correct questions to be asked, which he was discussing, retainage, the exact amounts. If you're a material supplier, the issues that can come about with the correct amounts, they're going to be in the system, so you know exactly what needs to be put into your form. So you can easily send your notices online in the SunRay system. It takes very, very, very short period of time. You don't lose your lien. You will not lose your lien and bond claim rights because we have an amazing, amazing reminder system. You can set your reminders to your Outlook or your Google Gmail. You can request your lien rights in just 60 seconds. You can request your preliminary notices in just 60 seconds. It's very simple. The information that we need is who you have a contract with, where you are working, basic information. And as I stated before, our system always has the correct statutory forms in the system so that you do not have to worry if you're going to miss something. It's already there for you. And as I stated before, the reminders are fabulous for you. You have 90 days. And again, that hasn't changed with the new statute. You have 90 days from last furnishing labor and material to the project to send a claim on bond. And I think maybe, Alex, if you'd like to touch upon this. Say, for example, you're on the project and you've been on the project for 70 days and you haven't been paid, and you know you're going to be on the project for 120 days, but you want to get out that specifically for material suppliers. So say you're there and you think that you're done with the project, it's 70 days, and you want to make sure that you've secured your bond claim rights. You send out that bond claim notice. You could always send an amended bond claim if you furnish more materials to the project. Alex, if you want to go into that in just a moment, that would be great too. And the last and most important thing that everyone has to deal with, and we have incredible webinars to discuss this, are our waivers. You can manage all of your waivers for free online. It's fabulous. So if you have a project that you're working on for a year, you can put all of your partial releases online, store them online, know exactly what you gave, so it's all organized for you. So that's the SunRay application. But I'd love for you to just talk briefly about that, because I know that can happen from time to time, and we have a number of questions that our audience has asked, so we'll definitely get into that. But
sure. So let me address the question that Ariella raised. The deadlines to record a lien or serve a notice are just that, deadlines. It cannot happen after those dates. But you can record a lien or serve a notice while you are still on the job. You don't have to wait until the job is done. And you don't have to wait till the 90th day. You could do it on day 7, on day 44. And we recommend to clients many times that they do, in fact, send those notices early as a collection tool. So don't wait until it's the last deadline. Do it early. So Ariella, what questions do we have?
So the first one is, what is the time frame to send the notice of non-payment? And that we just briefly went over, but again, you have 90 days, specifically on your claim on bonds. You have 90 days from the last day you furnish labor and material to the project to submit, to send your notice of non-payments. And you have 1 year to sue on the bond. And like Alex said, you certainly do not want to wait last minute.
correct. One of the things, while you're getting the next question ready, we have an app. It's called the Calculane. You can go to the App Store or the Google Play Store, and it'll help you calculate both the notice to owner and lien and bond deadlines. What's the next question, Ariella?
Actually, this is a fabulous question, and I think everyone is going to appreciate this one compared to having a lien on a project versus a claim on bond. And the question is, and this is great news for people who have bond claims, what about claims with a pay if paid contract?
Wow, we could do a whole seminar and webinar on those topics. And actually, before I answer the question, our next webinar is how do I get paid after I make a payment bond claim? We do these webinars for free every month, 20 minutes in and out. So the next one's on September 19th. And we have a live seminar that we do several times a year here in South Florida. The next one is October 22nd from 8 to 11. We take a deep dive into lien, bond, and contract issues, all focused on getting paid. You can sign up at sunraynotice.com/education. The short answer to that question is that you can get paid on your payment bond claim by timely submitting the notice. You have to follow up with your own collection efforts, and the issue with respect to making the payment bond claim versus a lien, my preference is if the job is bonded, and you'll know that, and SunRay will tell you that, and they will file the proper forms, but that's determined at the beginning of the project whether the contractor places a bond, a payment bond on the job or not. If they don't, then you need to make a lien claim.
Okay. So there was a question at approximately 9:04 that was specific to a slide. This is only for residential. So if that could rack your memory, I'm not.
Yeah, so with respect to the permits and the criminal penalties, those only relate to residential construction. That means where you're dealing with Mr. and Mrs. Homeowner.
Okay. This does not apply to commercial at all, question mark. How, if at all, does this apply to commercial projects?
The law is not intended to apply directly to commercial projects. It was written specifically for residential projects. That being said, if you do some of the things that the law prohibits, you could still be subject to criminal penalties. So you have to be extra careful about taking deposits and not doing the work. That by itself would potentially be considered fraud and a problem.
This applies to all project types, correct? Commercial, industrial, etc., not just residential.
So if we're talking about the notice of non-payment statute, that applies to both public and private work, commercial and residential. The statutes with regard to permits and the deposits, that statute is only related to residential.
So there is no date, time for the notice to be sent on retainage under 10%.
The statute says that you don't have to send a notice if all you're owed is less than 10%, meaning the time doesn't run. However, my advice to you is that you, whether it's just retainage or not, you timely serve within 90 days, no later than 90 days from your last work, you serve that notice of non-payment.
Okay. The new claim, on the previous notice of non-payment, we inputted bond numbers. This one, I don't see where it is requested.
Technically, the old form under the statute did not require the bond number. It's always a good idea to put more information, but it wasn't required. So you can add it to this form if you'd like. You can say that it applies to bond form, bond number thus and such. That's okay.
And I'd like to add to that, one of the points, and when you add the bond number to your notice of non-payments, it doesn't create havoc when it goes to the surety companies where they're trying to determine what bond it relates to. So it creates greater organization for you when you're claiming that that notice of non-payment. Okay, we have about 1, 2, 3, 4. We're about 12 more questions. So.
Oh my goodness. Okay.
So, is there a drop dead date that we have to send a notice of non-payment? Don't want to send one late. And absolutely, there is a drop dead date. We went over that. That's 90 days from last furnishing materials or or labor. But again, you do not want to wait until the final hour. It's imperative to create a very healthy process in your company that if you're at, say, 70 days, you should start considering putting that notice of non-payment. Okay, the next question is it correct that you can submit a notice of non-payment for retainage at any time, even after 90 days? Is there any limit on the time during which you can submit a notice of non-payment for retainage?
So you still need to file a lawsuit no later than 1 year from your last work on the project. So that will be the outside deadline. But again, if all you're owed is retainage, you don't need to serve a notice of non-payment just for that retainage. But remember, if you're owed 10% retainage and $1 of contractor change order amounts, you need to serve the notice of non-payment within 90 days.
And as for a copy of this webinar of the new lien law changes and for Florida, as well as the new lien law changes for Louisiana, we are happy to send you copies. The next question, good morning. That will be sent out within the next week. So good morning. If I have filed a commercial claim of lien and the customer wants to process a partial payment, does that affect the validity of my lien? And I'll let Alex answer that. So long as you do a partial, give them a
Correct.
partial satisfaction. If you satisfy the lien completely, you will waive your lien rights full stop or amend the lien. What you want to do is do a partial satisfaction to the lien. But go ahead and if you want to answer that as well.
Yes, so Ariel is absolutely correct. If you are owed money, let's just say you're owed $50,000 and the contractor or owner, and you've recorded a lien, and the contractor or owner want to give you a partial payment. So let's say they want to pay you 30 of your 50. What you want to do is you want to record a partial satisfaction of that claim of lien after you get the check. By the way, you don't want to record the partial satisfaction before, so you can prepare it, exchange it for the check or the payment. You can always amend your lien within the original 90 days that you have to record it. But even still, we typically recommend just preparing and recording a partial satisfaction of the lien. But you have to be very careful that you don't sign a release or a satisfaction of that claim in excess of the amount of money you're getting.
And I also want to point out, I know that there are terms that could be very confusing. When we're speaking of a partial satisfaction or a release, we're not speaking of the waivers, like a notice goes to the waivers and releases. We're speaking of an actual partial satisfaction that is recorded in the county where the lien is recorded, or where obviously the project is located. So it's not a waiver, it's an actual completely separate statutory form. I know that some people can get confused with the terminology. Just wanted to add that as well. Okay, so a few more questions. Approximately 9:09, we had this question. It says, does this apply to commercial construction as well?
Right, so that would have been the statutes regarding either the permits or the deposits, and again, that only applies to residential.
Okay. Do these changes apply only to residential, or do they also apply to commercial? I believe we've answered that as well. But
correct.
Okay. Do we have to send a notice of non-payment on the same date that we filed our claim? Is that okay? Or does the notice need to be sent before? If yes, how much before?
Okay, so the steps are as follows. Generally speaking, and there are some exceptions to these rules depending on who you contract and whether or not who you contract with and whether or not the project is public or private. But generally speaking, you need to serve your notice to owner / notice to contractor no later than 45 days from your first work on the job. That's the outside deadline. Ariel, I'm not sure, there's an echo. Maybe it's your computer. So once you do that notice, then the next notice, so that's the notice to owner, notice to contractor. The next notice is the notice of non-payment. That's the one we went over, effective October 1st, and that needs to be served on the contractor and the surety no later than 90 days from your last work on the job. There is no other claim. That notice is the claim. So the final step after that is that you will have to file your lawsuit on that payment bond claim, that notice that you served, no later than 1 year from your last date of work. Those are the 3 deadlines that matter.
And the next question is, did the time frame change from 40 days to 90 days? And the answer is no. And I want to go over one little kind of area that everyone knows of, the 45. A notice needs to be received by the 45th day. A notice needs to be sent really by the 40th day and stamped by the U.S. manifest at the post office. So if it's not received by the 45th day, you're still good. So think of it really 40 days instead of 45 days, because the notice needs to be received by the 45th day. So if it's
just Ariella, let me interject.
Yeah.
Just to be clear, the notice that Ariella is talking about is the first notice, the notice to owner, notice to contractor, not the notice that's in the materials, which is the notice of non-payment. That's 90 days from last work.
Next question, and we only have 4 more. And these are the last 4 we're going to take. And if anyone has any additional questions, Alex, if you could go to the slide with our contact details. You could please feel free to ask us. Can you use the form, or must you use the form for notice non-payment on private jobs as well as public jobs?
If you have rights to make a claim on a payment bond, whether it's public or private, as of October 1st, 2019, the form that I've showed you that you should be able to download, that's the form that you need to use.
Okay. Are there any new laws due to commercial projects? We went over that, but
correct. No substantial changes to the law with respect to commercial projects other than what we talked about.
Okay. Well, Alex, you did, as always, an extraordinary job. And if anyone has any questions, please feel free to either call us or email us. We would be happy to assist you. And I wish everybody a fabulous sunny day.
Thanks, Ariella. Everyone have a great day.